Peterson, Justice of the Peace for McLennan County, Precinct 1. And we're here this morning on an eviction suit. I now calls number J12V24-0977. The plaintiff in this suit is the Century Waco LLC, who is represented this morning by attorney Peyton Rogers. Good morning, Miss Rogers.
Good morning, and I do have my Juris Doctorate. I just don't have my license.
Okay. So you're not an attorney, but you
yes,
are.
I have my JD. I just don't have my license.
Gotcha. Okay, thank you. And the defendant in this suit is Jacob Brown, Jonah Brown, and all occupants. And with us this morning is Mr. Jacob Brown, right?
Yes, sir.
And you're here on behalf of Jonah as well?
I am, sir.
All right, okay. All right. So you have both waived your right to a jury trial by not requesting one, which brings us to a bench trial or trial by judge. That's what we're doing here today.
Yes, sir.
This being the people's court, you're not required, no one is required to have an attorney. In this court, you can have your voice heard and have judgment rendered following proper procedure. So the first order of business is to swear in the witnesses. So I'm going to ask you both, simply raise your right hand so I can administer the oath. Do you, both of you, solemnly swear or affirm testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. All right. Thank you. Now, Mr. Brown, how this works, the plaintiff is responsible to present their case, as they are the ones that filed it, to the court. It's imperative that both sides are heard. I will tell you that when Ms. Rogers is through, when she completes presenting her evidence, Mr. Brown, you have the opportunity to ask her any questions about what is presented, not your defense, but what is presented to court. Once you're satisfied that you've heard everything and that you understand everything, I will then give you the opportunity to give your defense if you wish to do so. That's entirely up to you. Understand that any testimony you give to the court, then Ms. Rogers is going to have the opportunity to ask you questions if she feels the need to. Okay? Once all the evidence is heard, then the court will render a decision. All right? Okay, Ms. Rogers, why don't you go ahead and proceed, please?
Thank you, Your Honor. This is a non-payment of rent case pursuant to a written lease. Lease was signed on December the 12th, 2023. Monthly payment, $1,295. Rent is due from November of 2024 through December of 2024. Total amount of back rent due today is $2,590, and that is for November and December. Notice to vacate was sent on December the 6th, 2024 by being posted on the inside of the main entry door. Your Honor, we're seeking possession, back rent, and cost of court.
Okay. All right. Just a couple questions on the rent. So the rent due, the total is $2,590?
Correct, Your Honor, for November and December.
Okay, that's 2 full months.
Correct.
Absolutely. All right. Okay, and how was the notice to vacate delivered?
It was posted on the inside of the main entry door.
Okay, very good. All right. And of the I'm assuming that the defendants are responsible for the full rent?
Correct, Your Honor. It's not subsidized.
$295. Okay, thank you. All right. Do you have anything else, Ms. Rogers?
That's it, Your Honor.
Okay, Mr. Brown, you've heard everything that's been presented. Basically, it's an eviction. You signed a lease. You have a valid lease, and you agreed to the terms of the lease, and you violated the terms of the lease, and that's why we're here today. Do you have any questions of Ms. Rogers about anything that was presented to court today?
No questions, Your Honor. Everything's pretty much,
Okay.
Everything.
Very well. Okay, do you have anything to say in your defense?
Just try to get caught back up, really. Would rather not get evicted. We're close. getting that 36. I was confident we were going to get it. I think the final was actually 36 with fees on top of everything.
Well,
Yes.
there may be late fees, and the court doesn't address the late fees, but it's still you're still obligated by the contract. So you're obligated to pay those late fees, but the court doesn't address those fees. Okay.
Yes, sir. And there's
All
no.
right.
My brother was out of work for a while. I was out of work for almost half the month of November due to a toe injury, and I work a physical labor job, so I couldn't work, so I couldn't get paid. But still, no excuses. We were given time to get caught back up. We thought we could. We were close, weren't exactly there yet. But no, it's really all it is. We tried to get there to pay it in full. We couldn't pay it in full. Partial payments are no-goes over here, which is that's cool. It's fine. But yeah, we gave it a shot, and it just didn't pan out in our favor right now. What I say now is that we are both working very steadily. I have the same job. He's back into work. Given any extra time, the bill would be paid. But I'm going to leave that up to you guys because I know now money flow is steady and it's coming together. The only bill that we have that has not been paid is our rent. So that's all of our focus going into January. But I'm going to leave that up to you guys.
Okay. Well, let me just explain to you that this is not anything personal against you and your brother. You understand that this is a business matter. That's what we're here for. I am obligated by law to hear this case and to pass judgment on this case. Now, this is not a negotiating court. I don't negotiate for one side or the other. I'll just state my findings, and anything that can or will be worked out will have to be worked out between you and the landlord. Okay.
Correct.
So, and I encourage you, once we are through here, to try to contact them and see if there's anything that can be done. But I'm going to pass judgment on this case because it's come before my court. But that's all we can do. I hope you understand that.
Of course. Yes, sir.
Okay. All right. Anything else?
That's all I have. There's really nothing
No,
else.
Your Honor.
Ms. Rogers, do you have anything else?
No, Your Honor. I was just going to let him know that, yes, any agreements between him and his landlord will be between them two. If you do have any issues with communication there, our attorney's office information is on the petition you were served with, Barry and Seward. We do have an email and a phone number on there. So if you do have any additional questions, please feel free to reach out to us as well.
Of course.
Okay.
Okay.
All right, then. Having heard the evidence, the court finds for the plaintiff for possession of the property and for the back rent of $2,590. The court will also award the plaintiff the court costs. That's the amount of money they had to pay to bring this case to trial in the amount of $264. Now, that is the judgment of this court. The judgments will go out in the mail today. Of course, tomorrow being a holiday, you may get it Thursday or Friday, but you'll get the copy of the judgment of this court. I want you to understand, Mr. Brown, that you always retain a right to an appeal. If you think an appeal is warranted, that's entirely up to you. However, it is a timely appeal. If you wish to appeal the judgment of this court, you must do so by Tuesday, January the 7th of 2025. And if you don't appeal, you don't take care of business, then you must vacate the property. Okay? And that is all we have. Mr. Brown, I want to thank you and good luck to you. I hope everything works out for you and your brother, but I'm going to go ahead and ask you to go ahead and remove yourself from this. We have another case coming right after this, okay?
So, thank you for taking
All right. And good luck to you.
Thank you,
Bye
Your
now.
Honor.
All right, Ms. Payton, we got another one that just popped up.
Oh, okay.
Go ahead and admit this one. Good morning. Who's on the phone, please? Good morning. Can you hear me?
Yes, sir, but barely.
Okay. Who do we have here, please?
My name is Alex Edwards.
Alex Edwards.
Yes, sir.
Okay, Mr. Edwards. Yeah, I have this right here. Okay, and all right, Mr. Edwards. I'm Judge Peterson. You've made it to your hearing, that's scheduled for this time. Now you don't have a video capability. You're just going to listen, right?
There we go. I thought I had it
There
on.
we
My
are.
bad.
Okay. Well, good morning. All
Good
right.
morning.
So, Mr. Edwards, this is an eviction hearing. I want you to know that you'll be able to see whoever is talking when they are talking. And with us now is Miss Peyton Rogers, who is the representative for 1911 Waco LLC, which is your landlord. So she will be representing and presenting the case for them.
Okay.
I want you to understand that we are being live streamed at this time to accommodate the openness of this court. Everything in this court is open to the public, and because this is a video hearing, so to speak, that's the way to accommodate and make it available for everyone. Okay?
Yes, sir.
So let me go ahead and begin. I want to call now. I call calls number J12V24-0975. Plaintiff in this suit is 1911 Waco LLC, who is represented today by Miss Peyton Rogers. Good morning, Miss Rogers.
Good morning, Your Honor.
Okay. I just want to let him see you. So, and the defendants in this suit are Alex Edwards and John Stuckey and all occupants. And with us this morning is Alex Edwards. Good morning, Mr. Edwards.
Good morning.
All right. You have both waived your right to a jury trial by not requesting one, which brings us to a bench trial or trial by judge. That's what we're doing here today. Neither side is represented by an attorney. However, this is the People's Court of McLennan County, and in the People's Court, you are not required to have an attorney. In this court, you can have your voice heard and have judgment rendered following proper procedure. So the first order of business is to swear in the witnesses. So I'm going to ask you both to simply raise your right hand so I can administer the oath. Do you, both of you, solemnly swear or affirm testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Yes, Your Honor.
All right. Now, Mr. Edwards, how this works, this is a civil suit that has been brought about by your landlord, and it is always a responsibility of the plaintiff to go first and present all evidence, any documents, any testimony that they feel they need to prove their case to the court, as they were the ones that filed it. And it's imperative that both sides are heard. I will tell you that when Ms. Rogers is through, when she completes her presentation, I will give you, Mr. Edwards, the opportunity to ask her any questions about anything she presents to court. This is not your defense. It's just what is presented to court. Once you're satisfied that you've heard everything and that you understand everything, I will then give you the opportunity to give your defense if you wish to do so. That's entirely up to you. Understand that any testimony you give to the court, then Ms. Rogers is going to have the opportunity to ask you questions about your testimony if she feels the need to. Once all the evidence is heard, the court will render a decision. Okay?
Okay.
All right. Ms. Rogers, please proceed.
Thank you, Your Honor. This is a non-payment of rent case pursuant to a written lease. Lease was signed on June the 20th, 2024. Monthly payment, $1,689. Rent is due from November of 2024 through December of 2024. Total amount of back rent due today is $3,378, and that is for a full month of November and full month December. Notice to vacate was sent on December the 6th, 2024 by being posted on the inside of the main entry door. Your Honor, we're seeking possession, back rent, and cost of court.
Okay. Mr. Edwards, do you have any questions of Ms. Rogers?
No, sir.
Okay. All right. So now at this time, it's your opportunity. If you wish to give a defense, you can do so at this time.
Okay, so as far as being backed up on November and December, I have tried to pay on multiple instances, and I have all that proof right in front of me. I know that they do not take cash, but I've gone in there with a cashier's check before. I've tried to pay online via card on multiple occasions, and I have that in front of me as well. I also have the proof that I've received a cashier's check and then deposited it back because it wasn't used for its intended purpose. So on multiple occasions, I have tried to pay this rent, and it just has not been taken from me. And then I'm also in a bit of a pickle because I did just file a police report for my roommate who stole $4,000 from me, which was the rent. And I have all the proof of that as well.
All right. Okay. Do you have anything else?
I believe that is it as of right now.
Okay. Well, I want you to understand that this court is not a negotiating court. It's not anything personal against you or your roommate. This is a business matter.
Right.
You've been living in this property and 2 months now have gone without any rent being paid. Now, you talk about they're not accepting it. I'm sure there's terms and has been terms on how to pay. I can't address that. I don't know if you can, Miss Rogers, but there are certain ways that they want you to pay. And if
Right.
you fail to do that, then it may negate that and then require you to do something in addition. But can you address that, Miss Rogers?
Mr. Edwards, when you tried to pay, were they partial payments and they refused to accept the partial payments?
No, they were full
You,
payments.
you tried to pay the full ledger balance?
Yes, and I have all that in front of me if you would like to see it.
Can you just tell me the amounts? Because I do have your ledger balance in front of me. Looks like it's $4,276.11. It looks like that's what they would need to clear that balance.
So there was $100 credit put on there. That's why it's
Yes.
4,200 right now. But
Yes.
the balance pre or prior was 4376.11, and then with the convenience fee of 5301, that brought it up to 4429.12. And I tried to pay that 3 times with 3 different cards, and it did not allow it to go through.
So typically, once you're in eviction status, they lock your portal online, so they don't accept online payments. I do have your lease in front of me, but typically, once you're in eviction status, they want that full ledger balance and certified funds. If you do have the full ledger balance as of today, I can do a 1 week reset and you can try to pay those funds. I would reach out to your landlord to see how they want those, but typically they won't allow you to pay online once you're in eviction status. So that was probably why the online payments did not go through.
Well, I also talked to the people at the leasing office, and they were telling me that I could do an e-check through CVS, Walmart, or HEB to get it paid, and I also did that, and I have the proof from my bank that I pulled all the money out. And I went to CVS, they weren't able to do it. I went to Walmart and HEB, and they said that there was an error code, and I have a picture of that error code as well.
Okay. Did your landlord tell you what type of payments they do accept besides cashier's
All they
check,
said,
money order?
all they said is that they do not accept cash. And then when I brought them the cashier's check, they said that we don't have a scanner anymore for cashier's checks. And I said, okay. They said you can pay online, which is why I tried 3 separate occasions to do so. And then they
Mhm.
said, oh, well, that's weird why that doesn't work. And then they said that you can do an e-check. And that's when I went to CVS, Walmart, and HEB to do so. And that was also not allowed to go through. So
Okay. And can you tell me how much you have to pay today?
um, as far as the balance or how much money is on me,
How much can you pay our client today? How much do you have available to pay today?
if I wasn't robbed completely blind, I would have the full balance. But I believe I have roughly 1,500, which doesn't get me anywhere with this.
Right. Yeah, unfortunately, like I said, if you had the full ledger balance today, I could do a 1 week reset so that you could pay them. If you don't have the full ledger
Mhm.
balance today, I've been advised to move forward, and then any agreements between you two would be post-judgment.
Okay, so even though I've been trying to pay y'all, that doesn't matter.
No, because you haven't actually made the payment, sir. And that's, I mean, I think Miss Rogers explained enough. Once you became delinquent, you're locked out of that portal, but it's your responsibility to do whatever it needs to be. You don't even have enough money right now to cover what is owed. And we're going to have to
But
proceed forward with this eviction. Okay.
I have all in front of me
I
proof
would,
that
well, I
I tried to
understand,
pay it
but
and I had the money at one point.
you don't have the full amount today. Okay, so listen, what I'm going to do is I'm going to move forward and give judgment on this case. I will tell you that anything that can be worked out is going to need to be worked out between you and the landlord, and whatever
Right.
that may be. But because of this delinquent and it's come to this trial, I will pass judgment today. I hope you get things worked out. Okay.
Yes, sir.
Do you have anything else, Mr. Edwards?
No, sir.
Ms. Rogers, do you have anything else?
No, Your Honor, I just wanted to inform Mr. Edwards if he does have any questions. Our law firm's information is on the petition for Barry and Stewart. There's an email and a phone number. If you do have any questions, please feel free to reach out. Okay.
Yes, ma'am. Thank you.
All
You're
right.
welcome.
All right, then. Having
you.
heard the evidence, the court finds for the plaintiff for possession of the property and for the back rent of $3,378. The court will also award the plaintiff the court costs. That's the amount of money they had to pay to bring this case to trial, in the amount of $256. Now, the judgments go out in the mail today. You should get them, well, tomorrow being a holiday, you'll get them either Wednesday or Thursday or Friday. But the judgments will come to you. Mr. Edwards, I want you to understand that that is the judgment of this court, and you always retain a right to an appeal. If you think that's necessary, you can appeal. However, it is a timely appeal. If you do wish to appeal the judgment of this court, you must do so by Tuesday, January the 7th. If you don't appeal, you don't get things worked out, you don't move out, then on January the 8th, they can proceed with a writ of possession, which is the next step in an eviction case.
Okay.
All right. I hope everything works out for you, and good luck to you. Okay.
Can I ask one more question, Your Honor?
Yes, you can.
So you're saying I have until the 7th to remove all my possessions?
I'm saying you have till the 7th to vacate the property, get things worked out, pay it out, or if you can't pay it out, then you have to move out.
Yes, sir. Thank you.
Okay. All right. Good luck
Thank
to
you.
you. Okay. All right, Ms. Rogers. Looks like we have one more, and no one has appeared yet, so we'll go ahead and do a default hearing. Okay.
Okay. Thank you.
All right. So I now calls number J12B24-0976. Plaintiff is 1911 Waco LLC, represented by Miss Peyton Rogers. And the defendant in this suit is Tiffany Forward and all occupants. While Ms. Forward has been properly served and notified of this suit, she has failed to file an answer with the court, and she has failed to appear for this hearing today. Therefore, we will move forward with the default judgment. First order of business is to swear in the witness. And one more time, Ms. Rogers, do you solemnly swear or affirm testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. All right, and you may go ahead and proceed.
Thank you, Your Honor. This is a non-payment of rent case pursuant to a written lease. Lease was signed on August the 5th, 2024. Monthly payment, $1,229. Rent is due from November of 2024 through December of 2024. Total amount of back rent due today is $2,458. Notice to vacate was sent on December the 6th, 2024 by being posted on the inside of the main entry door. Your Honor, we're seeking possession, back rent, and cost of court.
Very well. All right. Is that anything else?
That's all I have today, Your Honor. May I
All
be
right.
excused?
Okay, well, let me pass judgment here. All
Oh,
right,
I
so
was like, that's it.
you're a little excited. So, having heard the evidence, the court finds for the plaintiff for possession of the property and for the back rent of $2,458. The court will also award the plaintiff the court cost in the amount of $149. So the judgments will go out in the mail today. You should get them either maybe Thursday or Friday, as will the defendant. Understand that even though the defendant had not appeared for trial, still retains a right to an appeal, but that appeal will expire on Tuesday, January the 7th, 2025. And if there's no appeal and no movement, then you can get your writ on Wednesday, January the 8th.
All right. Thank you, Your Honor. That's
Okay.
all I have today. May I be
All
excused?
right. Yes, you may. And you have a happy new year.
Thank you, Your Honor. You too.
We are adjourned. Bye.
Thank you. Bye-bye.
So good morning. I'm Judge Peterson, Justice of the Peace for McLennan County Precinct 1. We're here today on an eviction suit. I now call cause number J12V24-0985. Plaintiff in this suit is Woodway Park Condominiums, who's represented today by Miss Jasmine Earl, property manager. Good morning, Miss Earl.
Good morning.
Good morning. And the defendant in this suit is Kelly O. Martin and all occupants. While Miss Martin has been properly served, notified of this suit and of this hearing, she's failed to file an answer with the court, and she has failed to appear for this hearing today. Therefore, we will move forward with a default judgment. First order of business is to swear in the witness. I ask you to raise your right hand. You solemnly swear or affirm testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, Miss Earl, thank you. I'll take judicial notice that you have provided the court with copies of some documents, namely the notice to vacate and the lease that you have with Miss Martin. I'd like to now go to the petition that brings us to court today. This petition was filed in this court on October the 19th, 2024. Plaintiff, Woodway Park Condominiums, and defendant, Kelly O. Martin, and all occupants. The property is located at 1536 Western Oaks Drive, Woodway, Texas, 76712, which is in JP Precinct 1 of McLennan County. The grounds for this eviction is for unpaid rent, which we'll get to in a minute. Notice to vacate shows to have been delivered on December the 9th, 2024, and shows to have been hand delivered to someone at the residence, which is proper. All right, now let me go to the, yes, ma'am?
One of the defendants is on the line. She says she's having trouble connecting.
On this one?
Yeah, on a job.
Oh, okay.
She has two, I believe.
Okay, well, she just dismissed one. That one got dismissed.
Oh.
This girl.
Okay, all right.
Yeah. You want me to transfer her on the phone because she's.
Yes, I want to do that.
Log in.
Okay, Miss Earl, the defendant is called into the office. She's having problems getting on, so I will
Okay.
go ahead and we'll go ahead and get her this on the phone, and then we can go ahead and continue. Okay?
Yes, sir. I don't know what I did.
Yeah. Look, let me see if you're. I'm going to ask to start and see if that helps you.
Start my video.
There you are.
I was trying to turn it up and I pushed the power button.
Absolutely. This is Judge Peterson.
Hi, Mr. Peterson. This is Megan Kelly Martin. How are you doing today?
I'm doing fine, Miss Martin. We've just started your case, but I understand you're having some technical difficulties and couldn't check in.
Yeah, I was trying to enter the meeting ID number for
Okay.
probably 10 minutes.
Well, you did the next best thing. So you're here, and you're actually here for your trial. So I will tell you that what we're going to do is going to let you go ahead. It's not necessary that you see everything. It's just necessary that you hear everything. And with us now is Miss Jasmine Earl. Miss Earl is the property manager for the Woodway Park condominiums. And she is going to be presenting the case for Woodway Park condominiums. So first order of business, I've already sworn in Miss Earl. And if you're going to give testimony today, I need to go ahead and swear you in as well. So all I'm going to ask you to do is simply raise your right hand and let me administer the oath to you. Do you solemnly swear or affirm testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Now, Ms. Martin, this is the civil suit. In all civil suits, it's always a responsibility of the plaintiff to go first to present all evidence, any documents, any testimony they feel they need to prove their case to the court. It's imperative that both sides are heard. I will tell you that when Ms. Earl is through presenting her case to the court, Ms. Martin, I will give you the opportunity to ask her any questions about anything that she presents to court. Once you're satisfied that you've heard everything, that you understand everything, I will then give you the opportunity to give your defense if you wish to. That's entirely up to you. Understand that any testimony you give to the court, then Ms. Earl is going to have the opportunity to ask you questions when you are through, if she feels the need to. Once all the evidence is heard, then the court will render a decision. Okay?
Yes, sir.
All right. And I was just going over, I've taken that, making judicial notice that the plaintiff has provided the court with the documents, copies of documents, and that the documents are the notice to vacate that was delivered and a copy of the lease, which we'll be going over in just a second. I want to go now to the petition that brings us to court today, and you have a copy of this petition, Miss Martin, that was attached to the paperwork that told you how to be here today. Okay, so if you want to follow along, you're welcome to do that. So this petition was filed in this court on December the 19th, 2024, plaintiff being Woodway Park Condominiums and the defendant being Kelly O. Martin and all occupants. The property is located at 1536 Western Oaks Drive, Woodway, Texas, 76712, which is in JP Precinct 1 of McLennan County. The grounds for this eviction is for unpaid rent, which we'll get to in just a minute. The next thing the court looks at is the notice to vacate, which shows to have been delivered on December the 9th, 2024, and it shows to have been hand delivered to someone over the age of 18 at the residence. And that is proper delivery. I'd like to go now to the lease. This lease is in the name of Kelly O. Martin and Woodway Park Condominiums, and the address is the same as on the petition. The terms of this lease is from August 24th, 2024 till November 30th, 2024, at which time the lease goes month to month until one side or the other decides to quit. So this is a valid lease. The agreed upon rent shows to be $1,200 per month, due and payable on the first of the month, and considered delinquent on the third day of the month, at which time late fees are incurred. And I go to the signature page of the lease, and I do have a signature for you, Miss Martin. You remember signing this lease on August the 24th, 2024?
Yes, sir. Yes,
Okay,
sir.
and by signing the lease, you accepted the terms of the lease, and that is basically why you are here today. So now, Miss Earl, of the $1,200 per month, how much does Miss Martin pay?
The full 1,200.
She's responsible for the full amount. Okay. Now,
Yes.
beginning with any partial months, what months are delinquent?
I have December, the full 1,200, and I'm not sure if we can ask for January yet, but they're still in the residence, so they still owe January as well.
Well, this is January the 2nd. So
Yes.
If there's not been paid, well, of course, it couldn't be paid on the 1st, but you're saying it hadn't been paid today?
No, sir. I still haven't
Okay.
received any payment.
All right, and that we can include January as well.
Okay, so
That
I have
gives us good.
2,400.
Okay, very well. All right, Miss Martin. Let me just, Miss Earl, do you have anything else to add at this time?
No, sir.
All right, then, Miss Martin, you've heard everything that's been presented so far. It's basically a non-payment of rent. We do have a valid lease and we do have an amount. Do you have any questions of Miss Earl at this time?
No, I mean, basically, we're gonna sell some jewelry to. This morning, she gave me the full amount owed, including the court costs and everything. And then the January's rent would be due as well. So that's kind of where I'm short on today.
Okay.
So yeah, I mean, what she's saying is accurate.
Okay. All right. Then I will give you this opportunity. Do you have anything to say in your defense?
No, sir.
Okay. All right. And I'm so sorry. I want you to understand, Miss Martin, this is not anything personal against you. This is a business matter, and you do have a lease, an agreement, and that agreement has been breached. So anyway, that's why we're here today. I'm going to go ahead and pass judgment on what I've heard so far. And I will tell you that if anything can be worked out, it needs to be worked out between you and Miss Earl. Okay. But because this case has come to court, I will be passing judgment. Okay.
Yes, sir. And what does that mean as far as being out of the apartment?
Well, basically, I'm going to give the judgment of the court, and then, like I said, if you're going to be given some specific stuff. If you can't do that, then you need to vacate the property. But I'm hoping you can get something worked out with Miss Earl.
Yes, sir. Okay, yes, sir.
Okay, Miss Earl, do you have anything else at this time?
No, sir.
All right then. Having heard the evidence, the court finds for the plaintiff for the possession of the property and for the back rent of $2,400. Now, Ms. Martin, I want you to understand that this only pertains to the rent. The lease does have a clause in there on late payments, but the court does not address the late payments. However, you are still obligated for the late payments with the landlord. Okay.
Yes, sir.
The court will also award the plaintiff the court costs. That's the amount of money they had to pay to bring this case to trial in the amount of $144. Now, Ms. Martin, this is the judgment of this court. I want you to understand that you always retain a right to an appeal. If you think an appeal is necessary, that's entirely up to you. However, it is a timely appeal, which means if you do wish to appeal the judgment of this court, you must do so by Wednesday, January the 8th. If you don't appeal, you don't get something worked out with the management, and you don't move out, then on January the 9th, Ms. Earl, you can proceed with a writ of possession, which is the next step in an eviction. Okay? Ms.
Yes,
Martin,
sir.
I hope you get things worked out. I sincerely do. But that is the judgment of the court.
Yes, sir.
The judgments will go out in the mail today, and you should get them. It's getting close to the weekend, so if you don't get it by Friday or Saturday, you'll probably get it Monday for sure. Okay?
Yes, sir.
Okay, sir.
All right. Thank you very much, and I wish you luck, and we are adjourned.
Thank you.
Thank you all. Have a blessed day.
You too.